Hey, Chris, good morning. Another exciting HIPAA webinar day. How are you doing today?
Hi, Ron. Indeed, it is. And hello, everybody. Thanks for joining. This is going to be really concise as a overview of some of the key aspects of what we're going to refer to as a set of guidelines and resources. And one of the really cool things about this set of topics, Ron, is there's really a spectrum of detail that we can go into. So today we're looking to give you essentially the basic core concepts, but we're going to link you to detailed aspects. And we also have bookmarks for these different sections we're going to hit on. So if you want to jump ahead, you can and really dive into the area or areas that might be pertinent to you. And we really encourage you to use this as a set of, again, resources that you can reference and get to the information and explanations of what you need. So anyway, with that, Ron, super excited to dive in today, and I'll turn it over to you to drive and sort of get us into the weeds here.
Sounds good. Thanks, Chris. So, a lot of the websites that we do here at Clarity, I think medical is probably our largest single industry. We do a lot of e-commerce across every industry, but the largest single industry is probably medical. And that may not be just the e-commerce. I mean, we're doing doctor-patient portals, medical mobile apps, and a lot of things. But today we're really talking about the HIPAA e-commerce, which is used for pharmacies, and when we're selling not only over the counter but prescriptions and managing prescriptions and things that a pharmacy and or medical website would do. We've got other ones. One of the ones that we've done is handymedical.com, where my grandma could go buy a wheelchair and it would automatically go in and check her Medicare and Medicaid and her copay and her insurance coverage and charge her accordingly. So that one had numerous integrations with that one. I think was an EHR called Tim's and some other things like that. So what we're trying to do is we have a lot of these HIPAA e-commerce projects going on right now. So the hope is today that we can guide you towards and talk very concisely about the main things about the HIPAA regulations. And so we're going to go forward a little bit and talk basically about the 4 HIPAA compliance rules. And we're going to break the rules apart. We're going to go to each one, and then we're going to actually go to the source of truth and show you where to get the actual government regulation and the rule, highlight some of them. And for each of those 4 sections, Chris mentioned we'll chapterize them so you can bounce in the video to each one of them. Each one of those also will have linked an additional video that goes even into more depth, where Chris has gone off and done some very in-depth, I don't know what the best word is, Chris, where he really went through the site and he read through the entire site, highlighting all the important sections for you and walking you through understanding the website, the government website, which can be difficult to understand. So with that in mind, Chris, these are basically the 4 rules. The source of truth that we typically go to is the hhs.gov site. So I'm going to turn it back over to you. And the first one we're going to talk about is the HIPAA privacy rule. So we're going to go over to the HHS website, and we're going to go down, and you can see as you go in, the website's got a lot of great navigation. It's got some tabs across the top. And once you get in, it's got some great stuff around here. And you can see that here's the privacy rule, security, the enforcement, the breach notification. These are the 4 that we're going to cover today. So I've gone to privacy, expanded that, and we're now on the summary of the privacy rules. So Chris, I'm going to turn it over to you and let you go ahead and dive in and give a nice description and whatever else you'd like to cover on the privacy rule.
Awesome. Thanks, Ron. And really, this is such an excellent resource. And it doesn't necessarily give you a lot of real world examples and really real life examples that help piece it together. So that's really one of the things that we try to do. But it is very concise and clear on a lot of the topics. There are a few areas on the site where it's essentially contradictory. But generally speaking, it's just such a helpful resource to have in your back pocket and make sure you're looking at it as a source of truth for HIPAA. Now, of course, one of the main areas of HIPAA is the privacy rule. That's really the genesis of HIPAA. And probably the biggest thing we want to point out is what the original intention and some of the major goals behind the privacy rule were and are. And so you can see that right out of the gate in the introduction section here. And to summarize, I would say, as it's stated on this site, a major goal of the privacy rule is to assure that individuals' health information is properly protected while allowing the flow of health information needed to provide and promote high quality healthcare and to protect the public's health and well being. And here's where it gets interesting: the rule strikes a balance that permits important uses of information while protecting the privacy of people who seek care and healing. And Ron, isn't this such a great summary of what we see throughout HIPAA? There's a balance. There's
Yeah.
some level of gray area that they're basically asking you to interpret based on the situation. So they're saying, given that the healthcare marketplace is diverse, the rule is designed to be flexible and comprehensive to cover the variety of uses and disclosures that need to be addressed. So, in some regards, this is really helpful, but in some regards, it's also really challenging because, due to the nature of it being flexible and due to the nature of it striking a balance, it by definition isn't clear. It's not as opinionated as one might want. And I think that is necessary in the environment that, these rules were created in. Things have been changing. I mean, just think about it. The rule originally came out in 1996. I mean, that's when
Right.
HIPAA was originally passed. Here we are now, you know, approaching 25 years later. I mean,
Yeah.
or over 25 years later. So, I mean, it's been a long period of time that this has really stood the test of time as a substantial framework. And really the core concepts of privacy are what you want to take away from this. And that's really, as we scroll down this page and look at some of these key aspects, one of the most important things to understand is who is covered and how are they covered by the privacy rule. And this is pretty interesting. I've found in my travels on the HIPAA journey that we've been on, Ron, that not a lot of people know for sure if they're actually supposed to comply with HIPAA, if they're required to comply with HIPAA. And I'd love for you to talk about that briefly and what your experience has been there.
Yeah, it's kind of strange. And one quick example of what you said a minute ago, and I'm going to scroll back up for just 3 seconds. The Office of Civil Rights. So if you hear us say OCR, we're talking about the Office of Civil Rights. Chris had mentioned in a previous video I saw, I think last week or the week before, how literally just in the last, I don't know, Chris, you can correct me, but month or two, they made, I don't know if it's an amendment or an addendum, but they are now allowing for the telehealth sessions. As long as you are not recording, you can actually use like FaceTime and some of the other things to have telehealth sessions with your doctor. But yet Zoom, where it's a recorded session, then falls under PHI because now you are storing data, right? So they've even made adjustments as technology has changed over time. And that's what Chris is saying. It's 25, more than 25 years old. And now they're trying to make sure that they've left it for room for interpretation due to the different types of organizations. I mean, we're dealing with, and part of Chris's question, when I deal with all these clients, I have one client that comes in that says, we report on when you're at a school and a teacher helps a special needs child. This client of ours, we help them build an application where the teacher could record their time. And all of that time gets submitted back to the state, and the state pays them for servicing them and reimburses them for doing that. But then all of a sudden you're talking about special needs and you're talking about kids and their behavior. Well, does that fall under PHI? Because that's not necessarily diagnosis related, right? So that in itself is in a gray area, right? So there's a lot of different things. So a lot of times, and this is one that as we scroll down, we came to is, who's covered by the privacy rule. And it talks about the different entities. And I think the term Chris uses a lot is called covered entities. So who does the umbrella apply to? And it's kind of like one of the examples I love to give is, Chris and I start a bank, or let's say I have a bank and Chris has his money with me. Well, if Chris puts a bunch of money in my bank and I'm holding it for him, I do not have the right to take Chris's money and go give it to anybody else unless Chris comes in and says, "Oh, I want to set up auto debit pay and I need you to pay for a car at Honda and I need to set up auto debit payment and I authorize that." Okay, well, that's now an authorized payment. And so now I can make payments on behalf of Chris, right? But Chris, on the other hand, he could walk in and somebody, as he walks into the bank, somebody, a homeless person could be standing there and say, I need some money. And Chris could hand them $20. So Chris can do whatever he wants with his own money, right? But I can't do whatever I want with Chris's money. And that is exactly the same by these providers. Chris could turn around and say, I've got herpes simplex 10, quoting one of my favorite movies, right? Beverly Hills Cop. I've got herpes simplex 10. And he could go around and tell anybody he wanted, or let's say I've got herpes simplex 10. I could go tell anybody that I want, right? I'm okay doing that. But if Chris was my healthcare provider and I went to him to get treated for that, Chris does not have the ability to go share that, sometimes even within his own organization, because there are access and security applications as well. Like he can't go tell the x-ray technician that Ron's got herpes simplex 10 because the x-ray technician, that has nothing to do with them. They have no right to that. Same with like the receptionist or someone else. The only reason why the receptionist may end up knowing that information, if I called in on the phone and said, hey, my herpes is flaring, I would like to set up an appointment for the doctor. And so then the nurse would say, oh, okay, well, knowing that, since that's not urgent, the doctor's out, you can meet with their PA. So there are certain circumstances and places where even the different people may or may not gain access or should have access, even within a simple organization. So, Chris, if you want to go in any deeper on that, but it is really difficult. And that's usually about where the first quarter of every single phone call that comes into me when people are calling about these projects, we literally sit down and talk about their business. We talk about what data is coming in, what data would apply to PHI, what security level. Do we need full security level where the data can be edited, where we have to actually track who has access to the data, when they access to the data, what the old value was, what it's been changed to, because it can be subpoenaed for court. Are we only taking prescriptions and those prescriptions can't be edited? So it's just an online pharmacy taking an order. The order comes in and we're passing that through to the back-end EMR or to the pharmacy to actually process the prescription. And since we're just storing data, but we're not editing the data, then we only have to go to what I call level 2 tier. We don't have to do the user level logging. But in one of the ones we just are releasing soon for one of the pharmacies we're working for, they'll actually, let's say, for example, I came in and said, hey, I want, I'm in pain from my back surgery. I need some Oxy. And so I requested a prescription of Oxy. The doctor could come in and say, I'm not comfortable with that, but I am comfortable with some naproxen. And so he can go in and edit that and change it and switch it and potentially change the dose and things. Well, now we're editing PHI information, and that falls into a deeper level of HIPAA compliancy when it comes to what data we track, what data we encrypt. So let me kind of pause and see if I hit where you were looking for, Chris, and I'll let you go on from there.
Yeah, thanks. And I mean, that's really the conversation we want to encourage the listeners to engage in is what are these different scenarios for you? And this is meant to be a pointer for you to be able to go and see the source of truth to answer these questions. Now, to some extent, and you can see there's actually a link where you can click here to say for help, where it says for help in determining whether you are covered. So you can go through that decision tool. It's really helpful. The one thing that I'll note here in general is that basically there are some great Q&A areas as well on the HHS website that we'll link to that also show different types of scenarios. They go through mobile applications, cloud computing, and software use cases, and have Q&A and FAQs about whether or not you would need to fall into HIPAA. So I think these are all really helpful. The main takeaway here is that we want to point you to this as a source of truth. I would say, just like you gave in the examples, Ron, there are some really interesting edge cases that, as you indicated, really tend to center around whether or not any data that we are passing through is transient or not, and what the scenario is. But generally speaking, if you're dealing with HIPAA data, PHI data in particular, rather, you're probably going to want to at least take the stance that you are dealing with PHI and HIPAA unless proven otherwise. And that is a really important thing. And ultimately, you can consult with experts in the field. We certainly are always interested and glad to help if you would like to engage in a complimentary discovery, just to see, what our understanding would be in your situation. We're not legal experts. We do a lot of HIPAA work, so you're always welcome to engage a legal counsel who will actually be able to go through the laws in detail. This is a summary, right? This is a summary from HHS. So in theory, if you want the literal source of truth, you're going to go to the actual laws. Um, but anyway, with that said, I think the other key highlights on the privacy rule are sort of getting into what the requirements are behind the privacy rules. So, one of the first things is to look at basically what information you need to protect. And I think if you just continue to scroll down on that page, you'll see it's essentially boiling down to this. PHI, or protected health information, is individually identifiable health information. And what is that? Well, it's information including demographic data that relates to the individual's past, present, or future physical or mental health condition, the provision of healthcare to the individual, or past, present, or future payment for the provision of healthcare. So we're basically talking about past, present, or future in general of mental health or physical conditions, as well as payments, and then any provision of healthcare. And so those are sort of the three big things. And it continues on to say, and that identifies the individual, or for which there is a reasonable basis to believe it can be used to identify the individual associated with that data. So this is really talking in implying the de-identification aspect, which is really a nuance that we won't spend a lot of time on today. But the main point is, what are these pieces of data that are referred to as PHI? And if you have a good understanding of that, then you can really sort of like stop worrying about it and actually do something and know concretely, this is actually what I need to do. And that's really our goal from this set of information, is for you to be able to take action on the right things and get to the source of truth, as opposed to worrying about it. So, Ron, any thoughts on these PHI areas, or maybe any examples that you might want to give or elaborate on here?
Yeah. Yeah. Thanks, Chris. That makes a total lot of sense. I'm glad you read that, because this is kind of the whole thing, right? It's past information too, because a lot of times people have this misconception where I'm only taking their name, address. I don't have a lot of other PHI information. Now, if you're not tying, right? Most people could go Google my name and they could find me or Chris up on YouTube and find, us on LinkedIn and Facebook and things like that, right? So our name is not considered PHI information. But if our name is tied to anything about a physical or mental condition about us, then that name could be used to identify the person they're talking to. So if we're talking about, if somebody goes, patient X has this condition, they're living at this address, well, then that address could be used, even though the address as a standalone is not PHI information. It falls under the umbrella now of PHI protected information, because that address could be used to identify the individual they're talking about, that medical case or that health condition. And this is where everybody falls down: the name, the address, the birth date, and social security number. So one of the things Chris mentioned, he just barely mentioned de-identification data, but one of the things that you can do is think about clinical trials. When you go to, like, we've got a number of different websites that we've built for people that have got FDA approval for medical devices, and then they've done clinical trials. And those clinical trials are published for everybody in the world to go see. But why can they do that when they see that, 100 patients who had cancer and they were treated with this drug and 84 responded, and the ones with the placebo, only 13 responded? Why can they do that? Well, the reason is because they've de-identified the information. They've either called them patient 1 through 100, or they've not individually numbered them, and they've generically aggregated the information and said, out of 100 people within the study, 50 received the placebo, 50 received the drug. Of the 50 that received the drug, 47 were cured. Of the ones that fit the placebo, only 13 were cured. So now there is a measurable, a 3x capability to be healed using this drug. And that information is the helpful information that the people are mostly interested. They don't really care who the people were. that attended the clinical trial. So they took that information about the trial, which was about 100 individual people that had this particular health condition, and they scrubbed the identification information from that, not the medical information, but the identification information. And that's what we call de-identification. So, Chris, any last thing on the privacy rule before we move on to the next rule?
Yeah, I would say in general, you're going to want to go through the actual nuances of what you're supposed to do with the privacy rule. And again, we do have a detailed video that goes over that. Ron, you did a great job of hitting on several of the core concepts from really a high level. The biggest thing that we want to say is it is not that hard to go through this summary of the rule, and it really will help you to rest at ease having gone through that. We literally have a video linked that we highlighted everything and went through and walk you through step by step. So if you're interested in doing that with us, we'll come along and join us and we'll walk you through it hand in hand, if you will. And with that said, Ron, yeah, I would love to move on next to the HIPAA security rule.
Sounds good. All right, Chris. So now that we're onto the HIPAA security rule, I'm going to go ahead and turn it over to you to dive into the rule and give us the ins and outs.
Awesome. Thanks, Ron. And for those of you who are watching and listening, one of the most important things about the security rule is there is a lot of detail here. There are a lot of nuances to it, but fundamentally, it has variability based on your specific business. And the general takeaway, the general summary with the security rule is that you want to meet or exceed industry best practices for security. And that is a very general thing. So we're going to decompose that and break that down and talk about what that looks like. But one of the most helpful things in general is if you're looking at the security rule page on the HHS Gov website, you'll see there are risk assessment tools that are complementary. They're free. They're built into the site. There are links here for the HHS security risk assessment tool, the NIST HIPAA security rule toolkit, and other guidelines on risk analysis. We highly recommend that you take a look at those and at least understand those. Now, one of the things that we tend to also generally recommend as a sort of an enhancement to these type of tools that are free from the government is it's great to look at these. You can use these. There are vendors who have created an entire business around helping you conduct the compliance on a regular schedule based on your business and based on your part of the medical industry. And specifically, they will also include, in many cases, compliance coverage. And so this can be a really nice aspect, a really key aspect to help you rest well at night. One of those partners is Accountable HQ. We work with them a lot, and they have a great offering for this. We'll leave a link in the description area, and you're welcome to get in touch with them, of course, directly. We'd certainly appreciate if you let them know that Clarity sent you. But they do a great job with overall HIPAA compliance and the HIPAA compliance auditing and risk assessment process. This can be really tedious and detailed, and it can be pretty challenging to keep organized and stay on top of the consistent basis of completing these audits, going through the steps of meeting or exceeding the industry best practices for security, and really making sure that you're logging and keeping good records showing that you're completing these steps and you are in compliance. So those are some things that we want to point out in general. And then as far as the actual security rule, if we would, Ron, let's go into the summary of the HIPAA security rule and we'll dive into that next.
Yeah, and I wanted to make one quick comment. You talk about the Accountable HQ, and if I remember, you just posted about 3 weeks ago a full deep dive video into the Accountable HQ tool. I'm going to go back and look for that, and if I do, I'll try to put a link for that as well in the description for everyone here.
Awesome. Thank you. So with that, really the summary of the HIPAA security rule is generally covered in the first few paragraphs of the page. And they talk about how it was established as a national set of security standards for protecting certain health information that is held or transferred in electronic form. And it operationalized the protections contained in the privacy rule by addressing technical and non-technical safeguards that organizations, covered entities, must put in place to secure individuals' EPHI, or electronic protected health information. And then within HHS, the OCR has the responsibility for enforcing privacy and security rules with voluntary compliance activities and civil money penalties. So these are essentially the teeth and the summary of how this mechanically works. Now, a great summary of the security rule itself and sort of what it does is a few more paragraphs below, where they say a major goal of the security rule is to protect the privacy of individuals' health information while allowing covered entities to adopt new technologies to improve the quality and efficiency of patient care. Now, this is really important because what they're doing here is they're giving you sort of a spectrum that you're going to be operating within. It goes on to say that given that the healthcare marketplace is diverse, the security rule is designed to be flexible and scalable. So a covered entity can implement policies, procedures, and technologies that are appropriate for the entity's particular size, organizational structure, and risks to consumers' EPHI. Now, this is sort of both at the same time a major weakness and a major strength of the security rule. And they're generally saying nothing and something all at once. And this can be really challenging to understand. So, probably one of the best things to do is to look at what exactly are some examples and what exactly are they expecting. And I mean, generally speaking, the goal here is to operationalize the privacy rule. So, keep that in mind. That should be sort of the heartbeat of why the security rule is there. And you probably want to think about the context of how the security rule came about. HIPAA, the overall HIPAA laws were published originally and established in 96. So there wasn't a lot of internet activity. There weren't a lot of massive security breaches and these kind of things. That really started happening later as the internet matured. This became a pretty substantial concern. And naturally, half a decade to a decade later, as sometimes legislation can go, there was finally a legislative consequence. And that was the security rule. And then the security rule was modified and there are guidelines posted, et cetera. So the point is that the security rule was intended to, as they state here, operationalize the privacy rule. And this means in technical and non-technical ways, but substantially they're talking about EPHI, so electronic situations. Now, one of the things that you can do is sort of get into, again, like I said, different scenarios. So if you go to the general rules section and you sort of dig into that, they say that specifically covered entities must ensure the confidentiality, integrity, and availability of all PHI they create, receive, maintain, or transmit. Identify and protect against reasonably anticipated threats to the security or integrity of the information. Protect against reasonably anticipated impermissible uses or disclosures, and then ensure compliance by their workforce. So it defines confidentiality to mean the EPHI is not available or disclosed to unauthorized persons. And it goes on to sort of talk about this. They define that integrity means the EPHI is not altered or destroyed in an unauthorized manner, and availability means that it is accessible and usable on demand by an authorized person. So you're getting some core principles here. You basically have this concept of authorization. What in the world is that? What does that mean? Think of it as a role. Somebody has a role or authorization to access something. They should be, only when they have that role should they be able to access information. You can kind of think of it as like a bank vault. And although certain people work in the bank, not everyone has access to the inner bank vault. So some people might just have access to a teller station. Others might be, opening and closing the door. Some might be doing janitorial duties, whereas other folks literally can go into the heart of the bank, the vault itself. And so this is the same idea with authorization. So who has access and who doesn't? And this is something that you need to formally establish within your organization and adhere to. So this is part of the security rule with EPHI. Okay. Now, another thing in general is this whole concept of integrity. And this is really important because there are a lot of electronic breaches, a lot of, ransomware and attacks that occur. And generally speaking, they're saying it should not be altered or destroyed. And this can happen, whenever somebody is, whenever there's a breach, the information can be altered. You think about it again with the authorization. Somebody could make changes to a record if you don't have strict enforcement of authorization for access. To give a specific example, the caregivers who are providing for a specific patient, they should have access, but only for a certain amount of time during which they're providing care and possibly need access to follow up on that. Someone within the healthcare organization or the covered entity should not be able to just search for someone randomly and get all of their PHI information. That's sort of the antithesis of this. Now, the other thing about the security rule is it generally is stating that there, and if you read on in this general rules section, when a covered entity is deciding which security measures to use, the rule does not dictate those measures, but it requires that the covered entity consider the following: size, complexity, and capabilities of the covered entity, the covered entity's technical hardware and software infrastructure, the costs of security measures, and the likelihood and possible impact of potential risks to ePHI. So again, this is really like it's saying you have to consider these things, and you're going to want to document them, and you're going to want to be at or above industry best practices for what's reasonable for your organization. And I'm not going to pretend to be a lawyer and try to interpret what this means for your organization. I can tell you though that generally speaking, our objective when we're working with clients is to adapt industry best practices and utilize those. And this really makes sense because of the way these rules are stated, to just go a little bit above and beyond, if not as much as you substantially can. And I think if you're documenting that and memorializing it and focusing on these aspects, that we need to ensure the confidentiality, integrity, and availability, protect against reasonably anticipated threats, so security issues or integrity issues with people accessing stuff they shouldn't be able to, protect against impermissible uses or disclosures, and ensure compliance by the workforce. So if you have those principles and you're focusing on doing this within the context of what your organization can do and the potential risk to ePHI, you're really getting at the heart of the security rule. Now, what are some of the mechanics of this? What do they really talk about as mechanical aspects? So this gets into the risk analysis and management. So you've got to perform risk analysis and overall security management. They talk about how there should be a risk analysis process that at least includes the following: evaluating the likelihood and impact of potential risks to ePHI, implementing appropriate security measures to address those risks identified. Now, again, you can use these free tools that are on this site, on the HHS website. They literally have them multiple versions, one from the NIST, one from HHS. And these are awesome tools. If you feel like, man, I'm lost, I don't feel comfortable doing this, try downloading one of those tools and going through it. It literally has a step-by-step set of instructions. And again, as Ron mentioned earlier with Accountable HQ, we also have a video walking you through where I actually go through this step-by-step and do a simulated example going through this assessment. So please, please do not let yourself feel overwhelmed by this. There's information and you can walk through this and get through this process. So you want to evaluate the likelihood and impact, and then implement measures to address those risks that you identify. Document the chosen security measures, and then maintain continuous and reasonable appropriate security protections. Okay, so they're basically saying, assess the risk, come up with a plan, implement it, document that plan, and then keep doing that. That's the summary. And then some of the things that they go into are extremely helpful. I'm just going to sort of bullet through these. So there are different categories of aspects they talk about. One is administrative safeguards, so security management process, security personnel, information access management, workforce training and management, and evaluation. And these are probably some of the biggest challenges that folks have. I would say generally training your team is one of the biggest weak spots with any security in general. But overall, having a process and constantly evaluating, and then having some form of feedback loop around who has access to what information, being able to modify their roles, and having a dedicated person. They say a covered entity must designate a security official who is responsible for developing and implementing its security policies and procedures. Now, a lot of times people will think of, they'll hear that and they'll think someone has to do this as a full-time job. That's not the case. They can do other things, but generally speaking, based on the size of your organization, you're going to need someone who has the time and resources to be responsible for developing and implementing your security policies and procedures. That's where a third-party tool or leveraging some of these guides that we've prepared for you can really help you to execute on that without having to make it a full-time job. For some organizations that are large enough, and you may be part of one of these organizations, you may have literal departments dedicated to this. So it needs to be relative to the risk and size and scope. They go on to go into a lot of other detail. I don't want to bore you with all of the detail. I just want to point out the technical safeguards as well: access controls, audit controls, integrity controls, and transmission security. Now, keep in mind, this is a summary. So if you want to get to the exact source, you can actually look at the laws that are backing this. They've summarized this for us. And, you're going to want to, if it gets into a nuanced detail, go to the actual law and potentially reference a HIPAA lawyer. That's fine if you need to do that. But ultimately, these summaries are pretty helpful. So access control, implementing technical policies and procedures that allow only authorized persons to access ePHI. So we talked about that earlier. This is the roles thing. Think about the bank vault and who has access to the inner vault. Okay. So you have to maintain that though, and keep that up to date constantly. Audit controls. And this one's interesting. And if you haven't heard of this, it'd be helpful. It's a covered entity must implement hardware, software, and or procedural mechanisms to record and examine access and other activity in information systems that contain or use ePHI. So that's pretty general, but it also is specific enough that it's talking about multiple layers of infrastructure and capability that have to be monitored with auditing. Now, again, if you want to get into the weeds, you can look at the actual laws, and there are some great examples that we'll go into with our HIPAA series, so you'll have that as well. But this is something that a lot of folks overlook: audit controls. Integrity controls, similar concept. A covered entity must implement policies and procedures to ensure that ePHI is not improperly altered or destroyed, and electronic measures must be put in place to confirm that ePHI has not been improperly altered or destroyed. Okay, so this is the same idea. This is something that a lot of folks overlook. So those two are sort of like blind spots for a lot of people. And then transmission security. A covered entity must implement technical security measures that guard against unauthorized access to ePHI that is being transmitted over an electronic network. Generally speaking, SSL is great for this, but really you can also encrypt the data and then send it over SSL. So effectively double encryption. I mean, depending on your situation, you can even do things with tokenization, de-identification, and then, basically putting yourself in a position where even if the data was compromised while it's being transmitted, it's not technically going to meet the definition of a breach. So these are details and nuances that one of the things I would say just in summary of the security rules section is they generally pass into other spaces like PCI DSS compliance, payment card industry data security standard. You'll see a lot of similar overlap in that space. And so there's a framework called HITRUST that is a nonprofit outside of HIPAA and the government, an organization that put together a framework or a blueprint for meeting and in many cases exceeding these standards, which is really what you want to shoot for. And if you follow that HITRUST framework, you're generally going to be following a framework that's going to get updates. They're going to keep you apprised, and you can essentially become part of a community that is adhering to HIPAA and generally exceeding some of the HIPAA requirements. So that can be a really helpful starting place as well, is the HITRUST framework. We have a series of videos that go into the different cloud hosting providers and just general infrastructure side of complying using HITRUST. Whether you're using, AWS or Google Cloud or Azure, we have detailed information on complying with HIPAA using HITRUST within all of those environments. So that might be really helpful. Ultimately, a lot of folks that are watching this, you might be overwhelmed just by hearing me talk about all these details. Usually the best thing that you can do is to work with an expert who specializes in this and even share this video with them if you'd like. We would love for you to take advantage of it and utilize it. We have detailed guides, and obviously we're going from the HHS website. And essentially, bringing you a summary of that. So you can collaborate with folks like ourselves. We offer a complimentary discovery, and we really encourage you to use the resources on the HHS website. Reach out to folks like us who offer these complimentary discoveries and just get answers to the questions that you have so that you can sleep well at night when it comes to the security rule. There are some details and complexities, but also keep in mind that right out of the gate, they state very clearly that it is variable based on what your organization can bear, essentially. And they don't want to inhibit your ability to implement new technology and improve the care that you're giving to patients. So there has to be a healthy balance there. Any thoughts on this one, Ron, before we move on to HIPAA enforcement?
Gosh, yeah, there's so much there. I think you said it really well. I love the bank example. I always use an X-ray technician example, right? An X-ray technician obviously has to, when they take my X-ray and they evaluate it and they upload the results, they obviously need access to my record, but they shouldn't be able to go into my record and see that whatever, I have diabetes or whatever, they shouldn't be able to have access to that other PHI information. And that's kind of what they're talking about to get very specific. A teller would never have access to go look in my safe deposit box, right? And that's kind of the bank example. And so that's where people, and especially the size of the organization, get hung up because, like my doctor I've been going to for 20 years, it's him and his nurse, Anne. Now, the great thing about them is he's old school. He's got the folders. So every time he walks in, he reaches back and grabs my 2-inch folder and everything is printed out and it's there. Well, this rule doesn't apply. Most of this rule doesn't apply to him because if you remember what Chris said, it was the ePHI and the electronic distribution and the ease of being able to breach, gain access to that information, and wrongfully share that information. Well, if he only has a printed copy in his office and it's physically locked and he and his nurse are the only two that have access to that, there's a lot less risk there. So that's kind of what they're saying is that you can go in and say, oh, okay, well, maybe instead of spending $20,000, and I'm making up numbers here, to set up all these different roles, maybe I only allow the PAs and the doctors who do have right to see everything access to the record. And then the X-ray technician will give me the results. And I, as the PA, would upload that into Ron's thing. And then I don't have to spend a whole bunch of money creating and monitoring all these different roles. And that's kind of what they're saying, that you've got this variability. You don't necessarily have to have the, again, making up numbers, the $300,000 solution. If a $30,000 solution will work with a little bit of manual workaround, you can be in adherence to the guidelines very strictly without having to spend the ton of money that the larger corporations would. And when Chris was talking about how some people have to have like the privacy officer, the compliancy officer, and all this kind of stuff, if you don't have time to do that, like my doctor, he doesn't have time to do that. It's literally him and his nurse. Well, he might come in and outsource that to a partner like Clarity, where we'll go in and sign a BAA and become an extension of their team and help them with that and walk them through the process and use tools like Accountable HQ or the NIST tools or the HHS tools off the website. So yeah, Chris, great job on the security rule. Let's go ahead and move on to the enforcement rule. Any closing thing on security, or are we good to go?
No, let's dive into enforcement.
All right, so now we're on to the HIPAA enforcement guidelines. So back over to the HHS website, and let's take a look at the HIPAA enforcement rule. So this kind of takes and talks about information on how they're going to enforce. And I know that there were some words in there, and I can't remember. I'm going to have Chris dive into this in a second. But I remember one of the things that it said when I was reading through this was it says that while it can, don't even know what the word, impart financial penalties, that it also can just come in and help with guidance and enforce rules, right? So it's kind of a tiered way that they punish. So if you are actively trying to comply, if you're actively using the tools, if you're doing things, it's going to bode very well for you because they're going to come in and go, okay, you're making efforts. You made a small mistake here. You just need to make this adjustment. And there may be no financial penalty if there wasn't an egregious error or breach of the PHI data. So it has a lot to do with your intentions and what you're trying to do. They understand that the rules are very vague. And so even when I went and read it, I got the feeling that they said, yes, we can apply financial penalties, but we also can just apply enforcements of guidelines and things like that, right, Chris? So I want you to talk just briefly about that and then go ahead and dive into the enforcement rule.
Yeah, that's right. And it's pretty interesting because, I mean, technically, you want to keep in mind that the OCR, if you take a look at the enforcement rules, it basically states at the top of the page that, HIPAA enforcement rule contains provisions relating to compliance and investigations and the imposition of civil money penalties for violations of the HIPAA administrative simplification rules and procedures for hearings. And it goes on, if you go to the enforcement process page, it kind of shows a visual display of how they go through a complaint and how they go through the enforcement. So here you can see a visual of the enforcement process. So um, they do generally start by just intake and review of a complaint, and that's the most standard sort of scenario that occurs. They do, of course, have the ability to run an audit as well. But most of the time, what we're seeing reported is someone is filing a complaint and then they're responding to it. So that in its nature means that if that is the standard right now, and that is what's going on typically, then it would make sense that you want to resolve any complaints quickly. Um, and of course, if there is any kind of a breach, which we'll talk about later, um, you're going to want to report it and show that you've done everything possible to have prevented it and have documentation, as well as that you have a plan for remedying it. But if you actually go into some of the case examples, which is just further down on that left menu bar there, you'll see different case examples for all the different scenarios where there have been cases, and it's organized by the type of entity as well as by the issue. So this can be really helpful to sort of clarify some of the different rules and how they're supposed to be, interpreted based on the enforcement of them. And so this can be, again, very helpful just in general, so you can get information. But one of the big things that you'll see as a common theme, and this is my interpretation, but they're basically saying, look, if you guys try to comply with this and you do a reasonable job and you document your plans and you train your team, and then any complaints or issues that occur, you quickly remedy them, we're not going to throw the book at you. But if you don't respond after we give you a heads up, I mean, there are cases in here, Ron, where literally the FBI contacts the covered entity and says, hey, we think you're getting hacked. And then the covered entity still doesn't resolve the issue.
Oh,
It's
no.
like, I mean,
Oh, my gosh.
I don't know what else to say. I mean, you're going to get generally some warning in a lot of cases, and there's no guarantee that they will or need to do that. It's just that's the tendency right now, and it's like if you get a warning or a heads up, respond to it and take it seriously, and that's sort
Yeah.
of the message that they send with a lot of these different cases and how they handle them.
Okay, so let's head back to the enforcement rules. So that was really good explanation, and it was a kind of a complex picture, and it looked like they have a lot of steps. But I really think that the clear message is, hey, make a good effort. If you've got a good effort, they're not going to nail you, right? But if they do come and put a shot across the bow, take it seriously. So if we want to back up a little bit, and give a little more detail about the enforcement rule and how it applies and what it means to our listeners today, let's go ahead and do that.
Yeah, absolutely. So, really, just starting out, I would say that's my general interpretation of the current stance that we've seen. I would be prepared at all times that that's going to change and get more strict, just based on the risk, especially for your organization. You're going to want to assess, just like the security rule talks about, what is the risk for your organization, and really, unfortunately, the reality is it is a spectrum. So please keep that in mind. And, each scenario is different, as far as what the risk level is and how much potential there is for breach, et cetera. So generally speaking, I would say go at least a little bit above and beyond. and leverage best practices and document that you're doing that and train your team. And these are very big generalizations, but if you pursue those to their end, to the point which it makes sense given your organization, then yes, I think that ends up being the case, that if there is an issue, it's going to be sort of someone who is trying to do the right thing. And generally, the tone of the OCR's enforcement has been that, again, from my interpretation, if they see an issue and they give a warning and they give a heads up, there may still be some enforcement, but it's going to be a lot less severe if you comply with them right away. And
Right.
you can see there's a lot of nuance to the enforcement rule history from this page. Generally speaking, the theme that you'll see, though, is that it's gotten more and more severe as far as who all is responsible for making sure that HIPAA compliance occurs. And then it essentially has become more and more clear as to what the responsibilities are with each of these different enforcement rule history changes. And ultimately, this is a really big thing. I mean, this is sort of like the teeth behind the HIPAA rules. And so you really want to understand them conceptually. And, if you want to get into the details, these actual laws are where you would go really as a jumping off point to get into the legal detailed laws that are the basis for this summary that we're going through. So we're going through just a summary, but it is from the OCR, which is essentially the group that's going to be enforcing this. Now, if we go to the enforcement process, this is an excellent resource because you can visually see what they do. And one of the things that I want to point out here is they literally have the option to refer this to the Department of Justice. So, I mean, that alone should be an indication of how serious this is. They do a review, they validate the situation, and determine if there's a criminal violation. So again, there's a potential with HIPAA that you are criminally negligent, and that could get referred to the Department of Justice. And, that could be really serious. So just keep that in mind throughout the process. Generally speaking, though, if it does go through the OCR, they're going to tend toward conducting an investigation unless they make a determination not to. And then they're just going to provide technical assistance, possibly down that resolution path. And, I think a lot of these scenarios end up falling into intake and review resolution, possible HIPAA rule violation, decide not to investigate, and they just make technical assistance available or recommendations. But that, again, is sort of the point, is if you're getting those, you need to take it seriously and understand, maybe they didn't decide to investigate at that point or refer it to the DOJ even. But, you've gotten some grace potentially. So fix it permanently. If there are issues they tell you about, take it seriously. Anyway, if it does go into investigation, then there are a lot of options here for how they sort of output from that. And one of the biggest things is they can obtain voluntary compliance, corrective action. They can charge penalties. And some of the penalties are nuts. I mean, the per incident, per patient breach cost, for example, or, violation that can occur technically can be dramatic. It can be very substantial. But one of the things that you can see, like if you have hundreds, thousands, tens of thousands or more patients, if there's a per patient incident that occurs, this can add up really fast. Some of the EMR, EHR systems have paid literally tens of millions of dollars because of issues and violations. So please take this seriously. But you don't want to be just overly scared about it either. And I know that's kind of like a oxymoron almost, but the bottom line here is that if you look at what they're saying here, they're basically going through this progressive process where they're trying to see if something serious happened. And one of the biggest things I can tell you is if there is an investigation or a review, they're probably going to be asking for what your processes were, what are your documentation, processes. What did you actually note as risks and then address? And this is probably one of the biggest things that I see most folks missing. So just keep that in mind. I mean, ultimately, that is going to show goodwill and at least that you are going to be a good actor in the space, even if you miss something. Um, you know, Generally, that's going to put them in a better position to not have to be as aggressive with you. One of the other things that I would note is if you go to the enforcement data page, this is also a little bit more detailed, but you can see that they list the cases as um, cases that they close fall into these 5 different categories. Now, you see this on that visualization, but this gives some links and it provides detailed text around each of these. And again, if you scroll down beyond that, you can see they go into enforcement results by year, enforcement results by state, top 5 issues in investigated cases. And these are just really, really helpful so you can actually see some of the types of problems that occur. And if you go into the top 5 issues in investigated cases, this is sort of like just a repeating situation. So impermissible uses and disclosures, that's the number 1 issue. Access and safeguards, that's number 2 and number 3. Depending on the year, there's flip-flopped. Administrative safeguards. And then finally, it gets into some of these other aspects: breach, notice to individual, technical safeguards, and minimum necessary. But there's a common theme here. It's basically like, are we limiting use, making sure that folks aren't doing things with the data that they shouldn't, like doing marketing stuff that's going to be impermissible use and disclosure, for example. Maybe someone internally has access to it that shouldn't. Do we have any kind of safeguards in place and administrative safeguards? And then again, it kind of goes into technical safeguards and minimum necessary. So these are sort of a theme that you want to get from the OCR about their investigated cases. And they're saying these are the ones that were closed with corrective action. So it's essentially, from looking at this data, it's pretty clear that they're saying, and I mean, they even go on to talk about it in different cases. But these are baseline things that anyone can do. Even if they aren't perfect, they can really tighten things down and lock them down. You almost want to think about it as like, think about a government base, for example, where everyone on the government base is just willy-nilly talking about the classified information that they're working on. And if whoever's in charge of that base doesn't actually tell everyone, hey, you need to stop talking about this. This is classified and it could cause the secrets to get leaked out. And hey, let's compartmentalize some of this information so it's less likely to leak out easily. I mean, these are just basic things that you can do. It's the same exact concept in general, but with PHI data. So anyway, I think this is really helpful to reinforce, and that's the whole point of it, is to reinforce the actual rules and, executing on them. Again, if you take a look at the resolution agreements page, you can see some really interesting cases. A lot of folks have problems with internally getting buy-in to do the work and put the time in order to reach, a certain level. This is really ammunition for that scenario. You have years of data where you can see in a lot of these, in the list, there are millions of dollars that were paid in these resolution agreements. Some of them are quite large amounts. And these are settlements essentially with the OCR, where they're basically ending up charging millions and millions of dollars. So isn't it much less expensive, not to mention the credibility hit? Isn't it so much less expensive to just fix the issues and operate like a classified government base? Keep the information secret, keep it compartmentalized, minimize the information that's getting out. And that's the same type of concept. There are also details here. We went through some of the case examples and talked about how those are available. There are also examples on the audit program and really how it works. So there's really a walkthrough of that. You can take a look at the audit program. You'll see that some of this is relatively older, and there was essentially a program to go through and do an audit, and have it go through a certain process. But yeah, in general, I think the biggest thing you want to note here is that the OCR is, from their communication and even some of their most recent messaging for settlements and et cetera, they really imply clearly, and they don't always come out and say it, but they really imply clearly that if you just have some of these baseline pieces in place, there won't be as much negative impact if you do have a breach or you do have an issue. If you're trying and you're doing your best, you're documenting it, you're training your staff, you're identifying risks, and you're going through the process of complying with HIPAA, it's, it's most likely that you will prevent issues with that. And so if there is an issue, there's going to be more grace, is the implication, at least. Again, I'm not the OCR, and I wouldn't say they're guaranteeing that in any way, but that does seem to be the implication in general.
Yeah. Two quick things. One, on that last one we just looked at on the agreements, there was two that just were settled like 3 weeks ago, right? So they're very active. I wanted to ask you one question before we move on to the breach. Back here on the enforcement rule history, do our listeners, do they have to go through every one of these? Are these like software change notices where they're just deltas? Or is this a rewrite update so we can go to, it looks like the most updated version is from 2013. Can we just jump into the 2013 as a listener, read that, and have a fairly good understanding of what the most recent enforcement rule looks like?
I would say you would need all of them, but the other thing that I would note is those are really, I mean, they're detailed legal documents, and anyone is
Right.
welcome and encouraged, if you want to read them, read them. But the OCR has put this resource together to really make a rule book for it. If you want to really make sure that you're complying, the biggest thing again that you're seeing here is this idea of proactivity, constantly being on the latest industry best practices for security, making sure that you're responding immediately to privacy and data requests, um, making sure that you're respecting people's privacy and minimum use, access safeguards, etc. Those are the things that you want to really pour your energy into. And that's really that's a lot of that you get with the SRA, security risk assessment, going through a lot of the compliance auditing, using tools that can help you stay organized around that, which there are free tools from NIST and from the OCR that can help you do that. But there are also great third parties. We talk about Accountable HQ all the time. They're
Right.
not the only one who does it, but they're a great partner that can help you with your HIPAA compliance and your documentation and auditing. So if I were to pour energy in first, if I hadn't done anything else, I would pour it into working with someone like Accountable HQ or with the NIST or OCR, HHS based SRA tools, security risk assessment, and just overall compliance auditing tools. That would be where I would put all of my time, and training my staff and reducing
Yeah.
access and documenting that I'm doing all of those things. That is really the meat and potatoes of this and what you see in all of these compliance resolutions.
Yeah, and two things where I would put my time from the white papers I've written literally in the last 2 weeks is work with a partner like Clarity, someone who can help evaluate your software. Because you remember, you saw all of the resolutions and what the problems were in the audits. The first thing was the access, right? That was issue number one for the last 5 years, was access. So have someone like a Clarity or someone evaluate your software, evaluate your tools, do an audit, make sure your tools are protecting and providing the ability to do that. The second one, you see the name here, high tech. There's a high tech blueprint for your security infrastructure. And that's the second thing that I would do. So, like Chris said, pour yourself into the tools, do the audit, and then at the same time, figure out, is your software allowing for the protection and the control over that access to the PHI? I know we talked about that in the earlier rule when we were talking about the privacy rule, back when we said, the X-ray technician could go in and upload an X-ray to my record, but that X-ray technician shouldn't be able to go into my record and see that Ron has whatever, type 2 diabetes, or, anything else that's not in their purview. They don't have right to that. So if you just give them admin access so that they can go in, take an x-ray, and have access to upload that to my record, and then they go see something else that's of interest and then share that information, that's where that access rule is. And so the people in the office and the rest within your practice need to have very scoped access to the data that is only applicable to what they provide when they provide it. Sometimes it's not as much as, well, they do that all the time, so they have access to that. Yeah, but they haven't seen that patient. That person hasn't been a patient forever. They shouldn't still have access to those records, type of deal. So anyway, I think we've covered the enforcement rule pretty well. Let's go ahead and let's move over now, and we'll talk about the breach notification, because that was one of the other things too. And that, I think, in 2021 was issue number 5. And that could be a failure to notify patients if their data has been breached, right? I remember we got a notification, I don't know how many years ago, it was 10 years ago. And I think Target got hacked, and the credit card information, right? They were violating what now we know as PCI DSS compliance. And so they were actually storing credit card numbers. And I don't remember how many million credit cards, but it was like a $210 million fine. And we were notified that our credit card, and so we went and had to cancel that credit card and go get another credit card, because we got a notification that Target leaked our credit card information, and we didn't want to have to deal with that. But we were properly notified. So let's go ahead and move on to the breach notification and talk about what is the breach notification rule. What does it mean to our listeners, and what do they need to do to either comply, or how does this affect them?
Yeah, thanks. This is pretty interesting. The definition of breach is shown here, highlighted on the screen. And generally speaking, it's an impermissible use or disclosure under the privacy rule that compromises the security or privacy of the PHI. And it's really broken into some of these different concepts or areas, the nature and extent of the protected health information involved, including the types of identifiers and the likelihood of re-identification. And we talk about this identification and de-identification in some of our other videos. The unauthorized person who used the PHI or to whom the disclosure was made, whether the PHI was actually acquired or viewed. So did they have access to it? And then did they actually acquire it, like physically get permanent access or view it? And the extent to which the risk to the PHI has been mitigated. They go into some detail about, so this again is the definition of breach. They go into some exceptions about what a breach isn't, essentially. The first applies to unintentional acquisition, access, or use of PHI by a workforce member or person acting under the authority of a covered entity or business associate, if that acquisition, access, or use was made in good faith and within the scope of authority. So in other words, if someone who maybe is, like you were talking about earlier, is a rad tech and they're doing some work on you, Ron, and they have permission to access patients' records, they accidentally mistype your name and they pull up somebody else's records because they have permission, but they are not going to do anything with it. And they were technically authorized in their role. That's
Right.
basically considered a good faith, breach. So it was a breach, but we're sort of saying, like, let's not worry about it. And then the second exception applies to the inadvertent disclosure of PHI by a person authorized to access PHI at a covered entity to another person authorized to access that information, either at that covered entity or another healthcare group in arrangement with the covered entity which they participate. So in other words, like a partner company, maybe it's a lab or something like that. In both cases, the information cannot be further used or disclosed in a manner not permitted by the privacy rules. So like, hey, if that happens and it's an accident, just stop, don't pass go, and everything's fine. The final exception applies if the covered entity or business associate has made a good faith belief that the unauthorized person to whom the impermissible disclosure was made would not have been able to retain the information. Now, this is sort of like the big catch-all I mean, think about this. This is really a lot of what you see with some of the new guidance that came out on telehealth.
Yeah, so it was interesting because you just mentioned this, I think, in a previous video. I remember you saying something like the OCR just put out a new ruling that with telehealth, where was it? It was on the iPhone FaceTime and on the Androids Google Duo are now acceptable forms of telehealth platforms because they don't record the call. So it's okay for a doctor and a patient, the patient to be on FaceTime talking with a doctor, have a telehealth session, because kind of what it's saying here, the information that is going could not really be retained because it's not being recorded, right? So with Duo and FaceTime, they're typically not recorded. There's no issue or no ability to go in there and easily record that. They don't record by default. And it doesn't store that data. So there's really not going to be a persistent breach of that data. It just allows the doctor to share the information with a covered entity and vice versa, but it's not going to be retained. Whereas with Zoom, I know I use Zoom on most of my demos every day, and we constantly record those and send the information and the demos to our clients. And so the presumption that Zoom is going to record is there. So if you use Zoom for telehealth sessions, then that could be in violation. So you would have to ensure that you're using a HIPAA compliant version of Zoom, not a regular version of Zoom. Otherwise, you could be in violation of HIPAA just by nature of that. So yeah, there's a lot of weird edge cases. And where this one is going to apply is not only it's intra when you're talking about the covered entities. For example, let's say I've got type 2 diabetes and I'm talking to my doctor in his office about my care. Well, that's one thing, and that's easy to control that within an office, right? So it'd be between me, my doctor, maybe the PA, maybe a nurse, maybe whoever's taking my blood. But then all of a sudden, if he says, I need to refer you to a hematologist and a specialist, now all of a sudden we're bringing in another entity. And so if my doctor calls that entity to have a conversation with them, and he's on the phone with someone telling them about my care, and it ends up being someone at that office that isn't supposed to have access to that data, but they took the call because the doctor was out of the office, that's where one of these breaches can happen. And that was kind of the second exception there, where it's an inadvertent disclosure of information to someone who they thought should have access and authority but didn't. So the doctor may not be held because it may fall under that second exception when they were like, hey, I called to share information as a referral for my patient. And, I asked you if you can take that information and you said yes. The implication was that you're authorized to take that information and you were not, right? So that would be under the second exception here. So it's definitely some gray areas. And I would assume that that's where some of those breaches are. So you were just talking about Zoom a minute ago. Do you want to extend any more information? I think I covered it briefly, but was there anything else about Zoom or any of the telehealth sessions that you wanted to finish out?
Well, I think it's a nice analogy to just data in general. Like a lot of times the data is going to be on a database or physically on a web server or maybe even on mobile devices because of a mobile app. And some of the data ends up getting stored because of caching or development practices. And you
Mm-hmm.
really want to think about this because by definition of breach, they're talking about in number one, basically the nature and extent of PHI and whether or not identifiers are there. And then really like, can somebody acquire or view that data? And, did they or not? And we sort of get into that in some of the breach reporting, but did they or not review that? That becomes the question. But if it was possible, then there's sort of this assumption that has to be made that somebody could have taken that data and used it for, a non-innocent use case, a non-good faith use case,
Right.
which if you click on the breach reporting page and we go take a look at that and just go through some of these concepts, I think it would be great if you were just to go over the highlighted sections here, Ron, and just sort of outline, what this is and how it works with how you're supposed to report breaches.
Let's just kind of go down. So, first one, submitting the notice to the breach to the secretary. we all have covered before what the covered entities are, and we kind of saw it above when we were looking at the enforcement, and we went to the different types of covered entities that they applied to and the different cases, right? So healthcare providers and pharmacies and different entities, right? So the covered entity has to notify the secretary if they discover that a breach of unsecured PHI data has occurred, right? And they've got a web portal that they've supplied. So there's down here, you can go in here and say, hey, if it's affected 500 or more individuals, you need to report this, and it differs, right? So it says a covered entity's breach notification obligations differ based on whether the breach affects 500 or more or fewer than 500 individuals, right? If it's affected by a breach is uncertain at the time of submission, then you should provide an estimate. So it's like, gosh, you know what? I'm not sure. We worked with a vendor. We were going to have them do an integration with our EMR, and we inadvertently gave them administrative access to the EMR so they could see all of our patients. Now, they were working with, theoretically, when we do integrations with EMRs, we don't necessarily get any access to the EMR because we're gained access to the API, right? So we're not in the EMR. We don't have rights to log into the EMR. We don't have direct access to the EMR typically. We only have access to the API. So you have to be very careful in working with third parties, especially in others. But anyway, the first one just talks about if you suspect a breach, it's better to stay ahead of it, right? So your security officer should go ahead and estimate, did the breach occur on more than 500 individuals' data or less than, and submit it accordingly, right? If it's affecting more, a covered entity must notify the breach without an unreasonable delay and in no case later than 60 calendar days. So if you figure it out and find out about it, it's like, hey, I just found out about it today. This problem's existed for years because it's built into our software and we didn't know this, but we found out about the breach today. The clock starts right then, and you have 60 days from the discovery of that breach to notify. And if you don't, that's probably when you're going to get in bigger trouble, right?
And Ron, will you click on the view a list of breaches affecting 500 or more and open in a new tab just so we can look at that? I just want folks to understand this is happening all the time, that there are folks reporting these, and you can look at the type of breach and you'll see most of these are hacking IT.
Yeah. So obviously here's a laptop was lost, right? But hacking emails or hacking network servers is the big one, right? Or here's a lost laptop and the theft of a portable electronic device, right? And again, many, many, many of them have been done. And it's just page after page after page after page. And if you look up here, look at the number of individuals affected, 100,000, 20,000, hundreds of thousands. And I don't know about, I haven't read a lot of them about the penalties here, but I remember a lot of the credit card penalties and some of the other penalties. They were fined. The last one that I read was fined. It was like $210 per record that was lost. So per credit card number that was lost, and it ended up being like 100 million. And I think that was Target. So I think it was roughly about 100 million credit card numbers, and they were fined $210 per record. So it ended up being, I think, $210 million. So you can see here by the sheer numbers, Chris was talking about how big the penalties can get. This is the reason why when you start getting into these hospitals, for example, here's a healthcare provider, there's 250,000 records that theoretically were hacked. And each of those records have numerous pieces of PHI data. So however they count data, do they count it only per patient? And so that's 258,000 assessments of the penalty potentially, or do they have different records and there were different violations based on the different records, and so there are multiple penalties per record, which could also take place. So is there anything else you wanted to cover here on this notification? I mean, so these are just the submissions, right? This is just the submissions. And
yeah, there's a lot, but I would say the thing to note about this is a requirement for being in compliance, and there isn't a guarantee that there will be any kind of consequence financially from this. But really, generally speaking, like whenever you're submitting one of these, you can see if you go back to the reporting, one of the things that, I mean, just generally speaking, is sort of like a thought, and I mean, it should be a thought in general, is that you're sort of, it's sort of putting something on the radar of the OCR. And, that's sort of the whole point here, is saying, look, you need to self-report if you have an issue, because it's not going to be very viable without them sort of violating rights of companies. It's not going to be very easy or viable for them to go in and do all of this reporting themselves without having an overall access to everyone's stuff. So you're required to report on yourself. And then my general recommendation, and you can again see this as their recommendation and encouragement, is make sure that you include what your documentation is around what you did to prevent it, what you thought the risks were, how you proactively worked to address those. You also want to document what you're doing to address the breach and what your understanding is about the breach, and then how you're going about reconciling it quickly. And if you do those things, you can at least minimize the damage and reduce the damage so that it doesn't reoccur. And if there was a potential breach, was it possible for folks to actually use that data? If not, that really makes it a lot better of a situation if folks couldn't actually use the data or if it was de-identified properly.
So really the only difference between whether it affects 500 or more or 500 and fewer is the time in which you must report. So in this one, it's no later than 60 calendar days from the discovery. And if it's less than that, it's within 60 days of the end of the calendar year in which it was discovered, right? It does talk about, though, you can report if there's multiple breaches. Let's say, like, you're working with a vendor and you accidentally give them access to a couple different test records and didn't realize it was real patient data while they were working on something. You don't have to report those individually. You can pool them together. So it says you can report multiple breaches, all of its breaches affecting fewer than 5 on one date, but you must complete a separate notice for each breach incident. So you would have to go in within 60 days of the end of that year and list out every single time that a breach potentially occurred. So it's probably better to just stay ahead of it. And each time there's a breach, no matter the size, just get them while it's fresh in your mind. Make sure you're documenting it. Make sure you submit the notification and the number of records, and then make a change to help prevent that, right? Anything else you want to cover on the breach notification before we tie off today's webinar?
No, I think that's really good. And ultimately, like you said, Ron, we want to encourage folks to work with a specialist in this area, and really, depending on how the scope and the nature of your projects that have HIPAA data, work with specialists that can own and help you with different aspects of your HIPAA and your compliance with HIPAA, as well as dealing with, changes and adjustments that you're making, and to just, overall create a culture within your organization and that of any vendors you work with, that they are encouraged to comply with HIPAA. And there's just a theme of being in compliance overall, and understanding that it is a cultural thing within your organization and within your vendor relationships to actually collaborate and focus on HIPAA as a long-term thing. It's not just a quick fix. It's not a one-time thing. It's an ongoing effort, and it's very serious and critical. So we hope that helps. We always, are open to the opportunity to provide complimentary discovery and review with you. And with that said, we appreciate you guys taking a look at this video. We hope it was really helpful. If it was, if you would be so HIPAA as to smash the like button. I don't know if it's even slightly funny, but thank you for smashing the like button and subscribing. We'll look forward to seeing you in the next video.
All right. Thanks, everyone. Bye, Chris. Bye for now.
Thanks. Bye for now.